Hi. I'm here for...
Right away, notice the confusion. Someone expected in court isn't there. In criminal hearings, missing custody transfers can delay everything. Quick question for you. Do you think defendants should still be allowed to proceed if they aren't physically present? Or should courts always wait?
Part of this one, but they didn't bring him. And this
Okay.
one was in custody. I know you start trial later this afternoon.
Yes. Well, if you can see, because I know that Judge Ron Rangel
Mhm.
has his docket, you can see if they're available.
Admitted.
Have him. Yes.
Okay, I can do that, and then I'll set him for Friday.
All right.
All right,
And
thank
if not, I'm sure they'll be able to get him, but it'll be in the afternoon.
Later, yeah.
Yes.
I mean, and I know you're starting your trial and all that stuff.
No,
I won't
I mean,
interfere with that.
but you may want to talk to Ms. Gay.
Yes. That's another question. Arlene is saying that she could take the paperwork with her and get it signed from Mr. Guzman at the jail. Is that appropriate? Is that okay?
Yeah, I mean, she can have it signed at the jail, but when is this going to take place? That's the problem.
Yeah, she has a...
This is where jurisdictional mix-ups happen. One jail says she's virtual, another says she's here in person. These issues can stall cases for weeks. Imagine being the defendant, stuck in limbo while two counties argue where you really are.
docket on Thursday. I mean, she has nine, so she has to see on Thursday and then
We
during
can't
trial.
have somebody sitting at the jail
Yeah.
waiting to be in the program. So if they're gonna bring him over today, then she'll need to be here this afternoon to take care of that.
Would you be able to do that this afternoon? I know
So
the jury
either,
get a trial.
because isn't Judge Rangel doing Friday?
Yeah, she says she didn't want, I guess she had free Friday.
I'll try to do it Thursday. I'll make.
Now, I don't have room on my schedule for Thursday.
Oh, okay, so Friday.
Friday's a good one.
Okay.
All right, who's here on Alexandria Alvarez? And where is Alvarez?
She is in custody of the Guadalupe County Jail.
All right, everyone, please whisper. Yes.
And so I had spoken with Norma, and so I wanted to ask you how you wanted to have it handled, where she is to attend by Zoom.
All right, do you have any objections to her attending by Zoom?
I don't know.
All right, so here's the question for the court on this case. It says virtual booking, but I'm being told that she's still in custody in another jail. So why is that? Does anyone know?
I do not, but I can see if I can. So I had not heard from the client in a while, and it came to my attention 2 days ago that she was in custody of the Guadalupe County Jail.
All right.
And then I entered a notice of appearance. I had initially represented her earlier this year for the same issues because there was a previous motion to revoke that was on file. So I'm continuing to assist on this matter, but she is in Guadalupe County.
All right, and so have you verified that she's in Guadalupe jail?
I have, yes, and I have that information. And
All right, if you can, and do you know, is the reason she's in Guadalupe based upon this case or something in another county?
it's based on the number ones related to these, so these are pending criminal cases. And then her information could be easily verified if you go to the website and then type her name.
All right, so what she's alleged in the motions to revoke are
Huge moment. Missing a plea deadline is like missing a train. Once it's gone, it's gone. Judges rarely reopen them unless there's good cause. What do you think? Should courts be strict on deadlines, or give some leeway if the defense isn't ready?
these burglaries of a habitation? Are they burglaries of a vehicle? What is it?
Multiple counts.
I have not seen the motion today yet. I don't.
All right, so if you'll confer with her very quickly, and then when you're all ready, just come back up.
Sure.
All right. All right, Esther De La Fuente. Hello. Hi. So today is your plea deadline date.
We're unable to reach an agreement. It's time you're on arrest for your trial.
All right. So here's the thing. Your plea deadline date has expired. The court will not accept any plea bargain agreements without good cause. Otherwise, you're going to have to plead open to the court. Do you understand?
Yes.
I'll just wait till you finish with your phone.
Waiting my calendar, Judge.
Okay.
You're going to give a date and I'm ready to.
All right. Awesome. All right, Ms. Ferguson, I need a jury trial date. How long do you expect this trial to last, date?
3 days.
3 days, and it's criminal trial division. All right, December 9th is your jury trial date. I need an acknowledgement of discovery signed if that has not been signed. All right, thank you. Just have a seat and your attorney will bring the reset form to you, okay?
Thank you.
All right, thank you.
Judge, I was not trying to, I swear I had my
There's no
calendar.
need to swear to me.
Sorry, I promise and affirm that I was looking at my.
Well, there's no need to promise or affirm. All right, and state on that one, just if there's any updates, because I do have in the system that a previous one was filed and signed. Juan Alberto Martinez.
Juan Martinez.
Oh, there you go.
Judge, can we hold off for just a minute? Pre-trial wanted to come down and make an interview with him.
Okay, sure.
We had back in August asked for a PR interview. Norma sent the
Here comes the heat. The judge calls out the defendant for not taking probation seriously. Remember, probation is basically a second chance. Skipping drug tests or violating terms almost guarantees a motion to revoke. That means straight to jail.
proper emails out, but apparently it's kind of slipped through the crack.
Okay.
So
All
they're
right.
coming over.
All right, thank you. All right, and is this a motion to revoke? What is this? All right, Albert Carl Gunther.
Good morning.
Hello, good morning. How are you doing today?
Once this is over, it'll be even better.
Hey. Oh, I know it's.
I believe you have it.
All right, thanks. All right, thank you. All right, so Mr. Gunther, let me ask you a question. Are you on probation out of this court?
Yes.
Then your actions are showing that you don't think that you're on probation because you're not following through on anything. You're not taking your UAs. And when you're drug tested today, what are the results going to be? Because you're going to get drug tested today. No, what do you mean?
Temptation to be negative.
When's the last time you used?
Been a while.
All right, what does that mean?
Maybe about a month ago.
All right, so what's going to end up happening is you're going to go and do a UA today. And if it is positive, a motion to revoke is going to be filed. So what are your results going to be before I send you?
Negative.
All right, Ms. Abrams, we're going to send you to get a UA. Do not stop at any other location but the location that Ms. Abrams is going to give you. If you end up going somewhere else, then a motion to revoke may be filed. Do you understand?
Yes, ma'am.
All right, so talk with Ms. Abrams. We're going to get a UA from you today.
Chief Judge.
Yes. Yes. All right, the court is calling 2025 CR 011977 and 2025 CR 007562A, State versus Andrew Thomas Reyes. Can I have parties announced?
Pertaining to the state of Texas.
Miguel Hernandez for the defense.
And are you Andrew Thomas Reyes? Counsel, in each cause number, have you received all the discovery and that you review that discovery with your client?
I have, Your Honor, and we have signed a document indicating that we have received all this stuff.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Reyes, in cause number 2025 CR 011977, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
Yes.
Did you understand in that cause number, you have a right to have a grand jury review the evidence and make a decision on whether or not there's enough evidence to hold you over for trial, and also that your attorney has certain rights. Your attorney has the right to have the passage of 2 days once they are presented with the information and 10 days to prepare for trial. Did you understand?
Yes.
Did you understand by entering this plea, you're giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. And each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
All right, off the record, to the clerk. Adriana? Yes, ma'am. I don't have the information in this cause number. Yes, please.
It's just the unofficial signed one,
All right.
unsigned.
And if you can make sure also, Adriana, that you have that.
You did the original one with the paperwork.
All right, we'll need to make sure that we have that before things are done. All right. Did you review the
Whoa, that's a massive amount of drugs. In Texas, 400 to 400 grams isn't just possession. It's serious felony territory, carrying up to 20 years. And yet, here the defendant might walk away with deferred adjudication, avoiding prison if they behave. Do you think that's fair?
felony information with your attorney? Did you understand it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, in each of those, are you waiving the reading?
We are, Your Honor.
State, in the cause number that is the felony information, are you proceeding on that information as presented?
We are, Your Honor.
In the other cause number, are you proceeding on the indictment as presented?
No, Your Honor, we will waive count one of the indictment and proceed on count two.
No objections, Your Honor.
All right, in each of the cause numbers, did you review the documents entitled court admonishments with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes.
And cause number 2025 CR 07562A, you're charged with possession of a controlled substance, penalty group 2, 4 to 400 grams as a second degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine. Did you understand?
Yes.
And the felony information, you are charged with endangering a child through criminal negligence as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into these plea bargain agreements, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cases?
Yes.
And just like that, the plea deal is locked in. Instead of decades behind bars, he's walking away with fines and probation. This is why courtroom hearings can feel so dramatic. The difference between freedom and prison can come down to one hearing like this.
Counsel, in each cause number, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Reyes, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
I am.
Did you understand by entering into plea bargain agreements in each of these cause numbers, if you're not a U.S. citizen, you will be deported, not allowed re-entry and denied naturalization. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea in the felony information case, punishment is to be assessed at a $1,500 fine. State recommends deferred adjudication. This will run concurrent with 2025 CR 0075628. And the other cause number, the state is proceeding on count 2. There's a $2,000 fine. The state recommends deferred adjudication, and it will run concurrently with the previous case. Did you understand that to be the plea?
Yes.
Defense?
It is.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, in the felony information case, the state is asking that your community supervision be for a term of 2 years. There be 100 hours of community service restitution, no contact with Skylar Reyes, parenting classes, TAP evaluation, follow all recommendations in the MRT. In the indicted case, the state is asking that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 200 hours of community service restitution, the parenting classes, and moral recognition therapy. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
You said no for us.
So you understood that?
Okay.
Did you understand that?
Yes.
Then, and cause number 2025 CR 007562A to count 2, how do you plead? Guilty, not guilty, or no contest? In 2025 CR 011977, how do you plead?
No contest.
State any evidence.
For both cases, Your Honor, state offers the evidence, states Exhibit 1, all attachments.
We've had a chance to review in both cases, Your Honor, and find no objections.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand, again, that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. All right, in each cause number, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client is taking full responsibility for what occurred in that house and on that evening. Because of that, Your Honor, and because of the fact that he has a clear record, we would ask that to be taken into consideration. The first thing we'd like to address is that the no contact order, although the state asked for it, he did go through a proceeding with the child custody people, and they found that he has had no problems with his child, so we would ask that he had at worst, no harmful or injurious contact with his child, so that he can see his child. He is supporting the child and taking care of all of his bills. Your Honor, he is working at this time, and so we would ask that the judge take that in consideration when considering, since the two cases are running together, the amount of community service hours he's doing. The TAP evaluations and the other things I explained to him were things that are probably good that he has to do. He does not have, they've done follicle tests and all kinds of other things, so he did not have any problems with drug use. And so we believe that'll clear him too, and they'll see all that. But we would just ask consideration on the fine, the no contact order, the no harmful or injurious contact, and consideration on the community hours.
All right, State, you want to be heard on the no contact order?
Yes, Your Honor. I wasn't sure if Your Honor would accept me putting in the harmful injurious contact as an option. But I will say we had the co-defendants about a month ago, if you recall, Jacob and Kelly. And I reviewed the CPS record associated with all three of them, including this defendant, and this defendant seemed to be the most, and he has a CPS, less culpable for the situation. He passed hair follicle very soon, so his, what they call family plan was cleared sooner than Jacob and Kelly were, the other two co-defendants, so the state have not had any objection. This particular defendant had no harmful and injurious contact with his.
All right, so were you living with these other people?
It was
So how many rooms did this home have?
3 rooms.
All right, and how many bedrooms?
Two at the time that I know of.
So it
that
was-
were being used as bedrooms.
Two were being used as bedrooms?
Yeah, the other room I do not. know what
All
was
right,
being
so
used.
where were the adults sleeping? Did the adults have a designated bedroom?
They did, but I know a bed frame like broke in the room, as they told me, so they're like living in the, we're sleeping in like the living room area.
So I'm just wondering, why would